Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and today on the docket, wow, we have a full docket. First, Heidi Broussard's parents say there's no way that she left voluntarily. Second, is there a time to kill? Third, an ex-DA and his chief of the Anti-Corruption Bureau found guilty of violating federal law. Oregon cops can no longer be chatty. Let's talk FISA and wiretaps and our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thank you for tuning in. We appreciate everyone that enjoys the true crime genre, and thank you for subscribing. If you haven't done so, please hit that subscribe button and hit that little bell for notifications of when we go live or put out new content. And as always, leave us a comment about what we discuss. We want to know what you think. First on the docket, Heidi Broussard's parents say there's no way that Heidi and Margot left voluntarily. For those of you who do not know, Heidi Broussard went missing last week. Her boyfriend, Shane Carey, said that he returned home and found her car at the house and everything else was there, but she and the 3-week-old child were gone. Shane Carey, the boyfriend/fiance of Heidi, went on TV and said that he has no idea where she is and he's worried and concerned. And we put that video up and you can take a look at whether you think he is telling the truth. Obviously, he has not been charged. And specifically, the Austin police have said that there are no people of interest at this particular time. So as always, everyone's given the presumption of innocence. But in the court of public opinion, you can certainly take a look and let me know what you think. Heidi's parents are looking for her and they are not giving up hope. Let's hope they find their daughter and their granddaughter safely.
As far as her leaving on her own accord, no. You can't make me believe that in 1,000 years.
Next on the docket, we ask the question, is there a time to kill? Let's see a show of hands of everybody who remembers that John Grisham book, A Time to Kill. Right? Remember, that's the case where the attorney represents the man whose young daughter had been sexually assaulted, and he kills the men that do it, and he goes to trial, and he's found not guilty. Well, there is a case in Wisconsin right now where a teen is facing life in prison after being accused of killing an alleged sex trafficker whom she says raped and filmed her along with other underage girls multiple times after she said no to having sex with him. Crystal Kaiser, she's now 19, in Milwaukee, and she was arrested June 9th of 2018 for allegedly shooting Randall Voller, 34. And he was allegedly shot twice in the head. And then it's also alleged that Miss Kaiser set his house on fire in Kenosha. Now, it's alleged that Miss Kaiser met Mr. Voller when she was 16 and that she killed him in the early morning hours of June 5th of 2018 when he pinned her on the floor after she refused to have sex with him. As Miss Kaiser was leaving the house, she apparently posted a selfie taken at Voller's house on social media with the caption of, quote, "my mugshot," end quote. Miss Kaiser is ultimately arrested, charged with arson and first-degree murder. She faces a mandatory life sentence in prison as well if she is convicted. In court, Miss Kaiser's attorneys are asking for what they refer to as an affirmative defense for killing Mr. Voller. Now, Mr. Voller is an alleged sex trafficker who raped and sold her for sex, according to police reports. And in fact, Voller was being investigated for sex trafficking before he died. At one point, the police seized computers and other evidence from Voller's home, and there were videos found of Voller telling underage girls how to successfully place ads for sex. Mr. Voller also apparently did not work, lived in a one-bedroom home in a rundown area of Kenosha, but he had $500,000 sitting in a bank account. And even more interesting, just prior to this incident, authorities found evidence that Voller had been abusing underage black girls at the same residence. Those allegations came about on February 12th of 2018 when a 15-year-old girl called 911 from Voller's house saying he had given her drugs and he was going to kill her. The police ultimately found this young woman wandering the streets, apparently high on LSD. She was able to tell the police that Voller had paid her for sex and that she was 14. Voller was arrested on charges of sexual assault on a child, and if you can believe this, had no bail associated with that charge. So while prosecutors say that Ms. Kaiser was acting intentionally, the defense is alleging that she was acting in self-defense. So an affirmative defense to be available simply states that, yes, I did it, but I had a reason to be able to kill this other person. Now, that would be usually self-defense. And to receive that instruction, you have to be able to receive some evidence, because some evidence has to be presented, a mere scintilla of the evidence for that jury instruction to be given. Now, at this hearing regarding Ms. Kaiser, the judge rejected her claim for an affirmative defense because she was basically being trafficked by someone for sexual abuse of a child. The law doesn't necessarily recognize that particular charge. So, what would Ms. Kaiser's attorneys be inclined to do? Well, they can certainly get up and have their client tell the story, since they want an affirmative defense of, yes, I did it, but these are the reasons why. And obviously, for self-defense, you have to state that you are in fear of death or serious bodily injury, or words to that effect to get that instruction. But simply saying I was a victim of sex trafficking is not a recognized defense under the law. Any good criminal defense attorney will tell you there are certain defenses that you have in a murder case. First is, my client didn't do it. Second, if my client did do it, it was in self-defense. And third, the dead guy needs killing, okay? That's the kind of the son of a bitch defense. The victim was a son of a bitch and deserves to be dead. That is what more than likely will take place, and it'll be a process of the jury saying we're sympathetic towards you, and basically a form of jury nullification if the jury is allowed to hear that evidence. Now, obviously, there is no jury instruction for the dead guy deserves killing, but everybody knows that the other guy deserved it. We'll see how this case plays out. We'll keep on following it. Now, our next case involves an corrupt district attorney and police chief. We go to New York for that, and former Suffolk County District Attorney Tom Spoda was found guilty on Tuesday for helping to cover up a former protege who is a police chief who punched a handcuffed man suspected of stealing embarrassing items from his police department SUV, including sex toys and pornography. Now, Spoda is 78, and the former chief of police was his anti-corruption bureau head, 53-year-old Christopher McPartland, who was also convicted of witness tampering, obstruction of justice, and conspiracy. The jury determined that Spoda conspired with Suffolk County Police Chief James Burke and McPartland to pressure witnesses to not cooperate with an FBI investigation into a 2012 assault. The prosecutor stated that instead of being leaders and standing up for justice, they did the best to manipulate the system and everyone who stood in their way. And if you can believe this, the district attorney considered anyone cooperating with the investigation into Burke to be a rat, demanding that a police officer find out who was cooperating, threatened that if anyone was an informant, that they would never work in the Suffolk County again. This DA and his police chief sound more like a bunch of organized criminals than law enforcement agents there to serve and protect. Yet another example of why, when these kind of situations happen, it completely destroys the faith in the criminal justice system. The police chief and the police involved told the officers that if anyone cooperated with the FBI, that their police union would not pay for any legal fees associated with their cooperation. We'll see what the future holds for this former district attorney and former police chief. somehow I don't think they're going to want to go to prison. I once represented a police officer who was convicted of doing some very bad things. And at sentencing, we tried to mitigate the sentence by stating that he was a police officer and that he didn't deserve to go to prison because he would be in solitary confinement during that time and wouldn't receive any good time credit. And the judge, a former prosecutor, said, "You had a badge, you spit on it," and sentenced him to the maximum penalty under the law. That's what should happen to these police officers and former district attorney. They had a badge and they spit on it. Next on the docket, Oregon police can no longer be chatty. Well, the police in Oregon are complaining after a Supreme Court decision in the state of Oregon that basically says if you're doing a traffic stop, you can only ask questions related to the traffic stop. Seems reasonable, right? But how many times has someone been pulled over by a police officer, and next thing you know, they're being asked 20 questions of, where are you going? What are you doing? Do you mind if I search your car? Boy, your friends look a little shady in the back seat. Do you mind if we take a look around? Do you mind if I search your car again? The Oregon Supreme Court said you can no longer do that, that you cannot ask any questions that were not supported by reasonable suspicion. Now remember, reasonable suspicion is a very low standard of proof. But if you pull somebody over for a speeding ticket, you give them their speeding ticket and you send them on their way. At a certain point, it's no longer a consensual stop as the courts have defined under Terry, which is a Supreme Court case that says, yes, it is a seizure, but it is limited in nature, and therefore it is permissible. So, police in Oregon or anywhere else, give people their ticket, send them on their way. Don't try and turn it into a drug search. Don't try and turn it into a DUI investigation. Give them their ticket and go. Unless, of course, it is an Aurora Police Department officer here in Colorado, and when he is so passed out, the police decide they're not going to do that. And what they did now here in Aurora was to ask the former United States Attorney to investigate this case, even though it should only take about a week to review the police report. The videotapes of the officers finding their fellow officer slumped over. I'm sure he will drag it out for the next 6 months, whereby nobody cares anymore and this matter goes away and the officer retires and nobody cares. We'll see. I'll care. I'll be watching. Next on the docket, let's talk FISA. Let's talk wiretaps. Now, a lot of talk has been going on the last couple of days regarding a FISA warrant, and that is the Foreign Intelligence Surveillance Court, which is where the FBI goes if they want to spy on U.S. citizens and basically of national concerns and get a warrant. It really involves national security type issues, and it has to be a very important or critical issue. Now, have I ever done a FISA warrant? No, I have not. Okay. Have I dealt with many a case involving federal wiretap cases? Yes, I have. And they're really the same thing. One just goes to a secret court. The other one goes to a district court judge, and they say, we are conducting an investigation. We don't want anybody to know that we're conducting an investigation. And they have to outline in a very extensive affidavit everything as far as what they know, which is inculpatory, as well as exculpatory. The prosecutors also have to show that normal investigative techniques would not work. Either those investigative techniques have been attempted and failed, or that they're somehow too risky to the investigation. Now, according to a wiretap records, in 2018, government records show the court fully denied only one of 1,080 final applications submitted under the FISA application process. Think about that, ladies and gentlemen. You reject one application out of 1,080, okay? And that percentage is about what it is for a regular wiretap as well. Some people will call that maybe a rubber stamp. Others will say, wow, those FBI agents are really good and thorough, and they know how to articulate everything they can, and probable cause has been established, and all the necessary boxes have been checked. And that's what it is. An application for a wiretap is thick, and it goes through everything that they know, or supposedly, but if those wiretaps are granted and it's basically found out that information was withheld or was untruthful, it would allow the individuals who are subject to the wiretap, who had some conduct against them, i.e. charges, to what they call a Franks hearing. And a Franks hearing is when you get to go in and say, you know what? The government was reckless in their information that they provided, or it was outright false and that they knew it was false, or they ignored it purposefully. And if you take out that information that was false from the application, and then you plug in what the truth of the information was that was false, would a probable cause still exist for that warrant to take place? And if that were to happen, the warrants fail and everything goes away as a fruit of the poisonous tree because the warrants were basically obtained illegally. But now, hopefully, with the chief judge that oversees these FISA courts slamming the FBI and saying, we're concerned about these inconsistencies that we have found took place before the FISA court, where, understand, only the FBI gets to go there. The other side is never invited. So the judge has to take these people at their word, and they normally do. But now maybe they'll take their word with a little bit of a grain of salt. Hopefully, when the district court judges get wiretap applications, they too will take what they say from the FBI with a grain of salt and say, prove it, get some more. Why do you actually have to do this? Okay? Or when they come back and it's been granted for 30 days and they ask for that extension after 30 days, they say, no, I think you've done enough. Why is that? Because your phone, you expect privacy. You expect when you're talking on that phone that you're not being listened to by anyone out there. It's completely intrusive, an absolute invasion of privacy, and should be the most extreme and last resort used for investigative purposes. And when the FBI lies, when they go and get these warrants, or state police officers do that, they need to be punished. But like we see in the FISA court, nothing ever happens to anybody in Washington, D.C., and hence nobody changes because everybody knows nobody ever gets in trouble. Now to our contestant for the Dumb Criminal of the Week. And today, once again, this gentleman comes from Florida, and his name is Elias Floor. Now, apparently Elias is a young 19-year-old male who likes to go to the Walmart stores. When Elias likes to go to a Walmart store like he did in Winter Haven, Florida, about 6:30 p.m., he apparently, or allegedly, I must say, and he is given the presumption of innocence, goes to the restroom, whereupon Mr. Elias comes out of the restroom, goes immediately to the toy aisle, removes his private part, and begins pleasuring himself in the toy aisle until he ultimately pleasures himself onto the pant leg of the mother standing in the aisle as he stood behind her with a small child looking on. Obviously, the mother is shocked and alarmed what her child has just seen, whereupon Mr. Floor leaves the Walmart. Unfortunately for Mr. Floor, and which makes him the Dumb Criminal of the Week contestant, is that why is that? Yes, that's true. Like most stores these days, their surveillance cameras cover just about every inch of the store, which captured Mr. Floor in his pleasuring escapade to Walmart. Ultimately, Mr. Floor's photo was put out to the police and to the press, and Mr. Floor ultimately turned himself in. Once Mr. Floor was in custody, he confessed to his pleasuring incident and is charged with 1 felony and 1 misdemeanor for a lewd act in the presence of a child. We'll see if Mr. Floor can win that Crime Talk mug or if he's just going to come in second place. That's all we've got for Crime Talk today. Once again, we appreciate you watching. We could not do this channel without you. Please hit that subscribe button if you've not already done so. Hit that like button if you liked the video, and please leave us a comment. Let me know what you think. Do you think Heidi Broussard's parents are being too nice and not being accusatory? Do you think there's a time to kill? And do you think that the ex-DA and police chief should get the maximum sentence? Let me know. Let's talk about it. Leave a comment. Have a great day.